My client's called the police numerous times.
This is why we appoint.
And so
We're going to check the offense report to see where the child was taken. Were they taken to CPS custody, state custody? Was there some other guardian? Once we're aware of where the child is, we are going to be asking for a no contact order to be granted based off of the allegations of the history of
What about now?
violence.
Is there something that we can do now as far as finding out where the child is?
Well,
You know?
we're going to call CPS today and see if they're in state custody. The offense report also might indicate where it is. If not, we can call the officer and they should know.
Yeah, I'd like to, because I think it's serious. I mean, if we have a history of violence, I don't want that to happen anymore. I know that you're telling me no, but I have other people that are telling me differently.
I've never.
Okay, well, ma'am, don't. No.
This is a family assault case. A mother accused of attacking her 15-year-old. But don't lock in your verdict yet. Evidence later changes everything. Watch the judge weigh safety, history, and video proof before a surprising pivot.
Ma'am, on that 15-year-old child.
I never assaulted.
Stop. Now's not the time. I'm just trying to tell you, if I find that there is a history of violence with the child, I'm going to order you not to have contact with this child.
I understand,
As it stands now,
but I promise there's no
I'm
history
entering
of
in all the
violence.
magistrate's order for emergency protection that identifies EJ as a protected individual. You
I have
cannot,
to take her to appointments and stuff like that.
please listen. Okay. Please, Samantha Walker. Ms. Walker, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge.
Okay.
On November 4th, 2024, an officer was dispatched to a family disturbance call at a residence in Harris County, Texas. The complainant, a 15-year-old, stated that the defendant, her mother, assaulted her after they got into a verbal argument. The complainant stated the defendant displayed verbally aggressive behavior towards her, grabbed a hold of the complainant's left wrist, and said, "If you come near me, I'll beat your ass," and began to engage in a physical altercation with the complainant. The complainant stated the defendant, using both open hands, placed the complainant in a headlock and the complainant felt pain. Both law enforcement and CPS records indicate a history of physical altercations and verbal altercations between the complainant and the defendant, and the officer observed video footage showing the defendant acting as the primary aggressor towards the complainant and observed a minor injury cut on the complainant's left arm.
So we have prior violence, any prior charges,
There's no prior
and
charge,
no
Your Honor.
prior injury to a child, felony charges?
No, Your Honor.
Okay, so you need to take the full
Child means 14 years or younger.
So she probably.
Okay, ma'am, I'm going to find that there's probable cause to go forward with the case.
No, Your Honor,
Don't. Now's not the time, ma'am. You have the right to remain silent. Exercise that right. I've got a bunch of DAs here. Anything you say, they're going to use it against you. Guys, what do we do about contact? You know? Yeah, well, so Michael, I need your help.
Yes, Judge.
You know, this is a 15-year-old child. We have a history of violence allegedly between mom and daughter.
Yes, Judge.
Now we have an assault case against a 15-year-old. And according to what Alex says, there's a history of it. It's unacceptable.
Judge.
Do you have a lawyer, ma'am?
I'll be retaining a lawyer, but there's no history of violence between us.
You're calling for a Walker?
Yes.
Which Walker?
One Walker. It's in custody. Thank you.
Okay.
So, what my plan was, and I already spoke to my people about this, is
Prosecutors push a no-contact order while the court confirms where the teen is. Translation: a magistrate's protective order can bar weapons, threats, and proximity. Violations stack new charges fast. When minors are involved, judges default to immediate safety first.
We're going to check the offense report to see where the child was taken. Were they taken to CPS custody, state custody? Was there some other guardian? Once we're aware of where the child is, we are going to be asking for a no contact order to be granted based off of the allegations and the history
What
of
about now?
violence.
Is there something that we can do now as far as finding out where the child is?
Well,
You
we're
know?
going to call CPS today and see if they're in state custody. The offense report also might indicate where it is. If not, we can call the officer and they should know.
Yeah, I'd like to, because I think it's serious. I mean, if we have a history of violence, I don't want that to happen anymore.
There's no,
I know that you're telling me no, but I have other people that are telling me differently.
I've never,
Okay, well, ma'am, don't. Now's not the time. But my primary concern is the protection of every single person in Harris County, bar none. That's it. Especially if it's a child. And
I'm not a threat to my child, I promise you.
you are now charged with assault, ma'am, on that 15-year-old child.
I never assault.
Stop. Now's not the time. I'm just trying to tell you, if I find that there is a history of violence with the child, I'm going to order you not to have contact with this child.
I understand,
As it stands now,
but I promise there's no
I'm
history
entering
of
in called a
violence.
magistrate's order for emergency protection that identifies EJ as a protected individual. You
I have
cannot,
to take her to appointments and stuff like that.
please listen. Okay, I know that you're trying to think of stuff to say,
No,
but
I'm
I
being
want you to
honest.
listen because this is very important stuff. And if you don't hear it correctly, you do something to violate this court order, they're going to file additional charges against you. I'm entering in an order for protection for that 15-year-old child. She's now a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Technical Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. Typically, this also comes with a residential restriction that you're not to go within 200 feet of where she lives or where she works. Do you understand? Okay, I'm entering this order now. We will try to figure out about how we go from here, but my only concern is the protection of this child. To me, nothing else matters.
She's protected.
I know that you're telling me one thing, but the evidence will show what it shows, and that's going to point to whose side is correct. So for now, I'm just going to have them reach out to see where the child is and how we go forward. So for now, I'm going to have you sign a reset, and then we'll just have you take a seat in the jury box, please. Okay?
I'm approaching you about police law. So I called Officer Cortina, in order to ask whether they applied CPS determinants, and they did. They took CPS, but they left the girl in custody of the grandfather. The grandfather resides in the same home. They gave me his number. I attempted to call him twice, left a voice message just to confirm whether or not CPS has since picked her up or whether or not she is still in the custody of the grandfather.
Why don't we wait a little bit too? Perhaps you left the number to call back, I'm assuming?
I left a voice message to call back.
Mid-hearing reality check. Prior CPS calls suggest an ongoing pattern, so the judge appoints counsel and keeps focus on the teen's safety above all. If you were the judge right now, what conditions would you impose?
Judge, but there is a history of violence.
How do you know?
The offense report states and the officer ran the call logs. And CPS has been notified multiple times about incidents occurring at the house between this complainant and her mother.
Okay. Right, I mean, I guess that's it for me. You know, if you have some kind of, if there are prior CPS calls, prior CPS intervention, then, you know, I'm going to appoint her someone now so that we have at least her talking to a lawyer,
Yes, Judge.
and then we can powwow. But let's give it, I mean, we've got time. It's only 9:45, right? So let's give it time. Hopefully they call back and we can get a better idea of where that child is, because the only thing that matters is that child.
Yes.
Nothing else matters, right? And that's what it looks like she got one. Great.
Mr. Helix will be.
Okay, there you go. So she can't go yet. We're trying to figure out where the child is. Okay? Of course, please do. That's what we want. We want you to meet with her, figure out what's going on, and then let us know. Yeah? Okay. Thanks, James. You guys ever get a call back?
No, Judge, we didn't. So, Judge, I met with the defendant with defense in the room.
Oh, okay.
I'll let defense.
Your Honor, I showed him some video of the alleged assault, I believe. Of course, I haven't gone through the state's discovery, but this, in my opinion, is a child out of control. She's on juvenile probation in Tarrant County, according to her mother. The complaint says that she caused bodily injury by grabbing her. I mean, the complaining witness has a statue. She's threatening to get a knife. She's bigger and stronger than my client. My client's called the police numerous times.
This is why we appoint.
And so
There's
I
always
think-
two sides, right?
I think this is almost enabling the child when the police come. The police saw all this, but they're so sick of going out there. They're like, we're somewhere.
But I don't understand why they wouldn't, if you see this, Michael, did you see it?
I saw the video, Judge. Based off of what I saw and what defense told me, I'm unopposed to removing the residency restriction, to not granting a MOAP at all, and to just.
No more.
I wouldn't.
Okay, I mean, if that's what you think, I'll go with what you think. I
Based off what
think,
they're telling me, Judge, and I did corroborate some of the information as well. We're just going to subpoena the CPS records to take a look.
come up, Ms. Walker, come up. So I guess the $25 million question is, how do you wrangle in a child who's out of control?
I've been doing everything in my power to love her, do everything to help her get some type of mental help. I've had her admitted to several programs. I've even contacted CPS myself personally, had them come out to the house. She got up and walked out on us. I've tried therapy. I've tried medication.
Hell hath no fury as a scorned 15-year-old. I tell you
None.
what, I mean, I
None.
remember I was 15. Oh God. And I hope
Game changer. After viewing video, even the state backs off residency bans and a protective order. Now we're in a gray zone: juvenile probation, past threats, and a struggling parent seeking help. The law balances parental authority with child protection.
doesn't, I mean, I know it's going to happen to me, but what's she on probation for?
Trying to stab her older sister, my other daughter,
And that's in Tarrant County,
in Tarrant County.
in a juvenile case.
Another felony.
Okay, so I'm at your disposal. I guess whatever you want, ma'am. I'll take off I won't do the order for protection. Just be careful, I won't put I'm not going to put any conditions either, I guess,
I would just say no threatening or harassing, Judge, if the court's inclined to do that. This is some sort of.
I mean, how do you handle a 15-year-old?
How can you be a parent if, it's almost like you're disarmed and the child can do whatever she wants. And if you touch me, well, you're going to jail, Mom.
Correct.
F you.
No, I mean, imagine that. The child will have unfettered access to.
And the
Just
arresting
wreak havoc.
officer told her, if you feel triggered, you can leave and take a walk. Well, that walk turned into her being gone for 7 days.
Oh, my Lord. You want to bring her here? She'll come here. I can try to talk to her.
Yeah,
Show her the jail. I don't
she's
know.
been to jail in Tarrant County already because she continues to violate.
And that's the juvenile detention, it's not the same thing.
I don't know. I mean, I don't know how worse juvenile detention is versus regular.
And she had an ankle monitor, but
I'd
it was
imagine.
cut off.
It's not like the jail.
Really?
Yeah, they're in plain clothes, they're not in handcuffs, they have plenty of hours.
Really?
It's completely different.
It might as well be a playground.
Yeah.
Wow.
It's not like Dr. Phil where he sends them to the.
No.
Okay.
It's a playground.
I'm not going to put any, just be careful. It's evident she's bringing you down too. And I'm so sorry for it. You're welcome to come bring her here. We'll try to help you out.
Yes.
If she'll listen to me, I'll try to talk to her or whatever you need. We're at your disposal,
Thank you. I appreciate that.
You ever need funds for anything, just let me know.
Okay.
That's why, I wanted to appoint you someone because there's always two sides, right? We get one side here, but a lot of times you don't get the other side. And a lot of times we take that for granted, and it's good to have another ear in just so that we always know we get a complete picture, and it's just so important. So I'm sorry you're going through that, and I hope it gets better. If you keep loving, I got to imagine she's going to get better, really. Because I tell you, I was the same way. Hell on wheels. You know, and if it weren't for my folks, holy moly, I don't know where I would be, you know, really. So, okay, man, thanks. So we've given you a lawyer. Just stay in touch with James. He'll tell you when to come back, what you need to do. I'll waive your appearance. You don't have to waste your time to come into court. Just stay in touch and then you guys work it out, okay?
Yes, sir.
Okay,
Thank
best
you.
of luck to you.
So it's the protective order and the,
No conditions,
and no
no,
conditions. Okay.
just,
Well, just hold on to it.
yeah, we'll shred it, just shred it.
Okay.
Yeah, okay.
Thank you, Your Honor.
Final take. The court pivots. No protective order, no added conditions, counsel appointed, CPS records forthcoming. Focus shifts to protecting the teen without over-criminalizing mom. What's your take on this ruling? Drop comment, hit like, and subscribe for dramatic courtroom moments.